the matter of DF and Essex County Council.
Yes.
My lords, my lady, I appear on behalf of the appellant, DF, leading Daniel Clark. Mr. Oldham, King's Counsel, leading Raphael Hogarth, appears on behalf of Essex County Council. I should explain that my client is not present in court. I'm afraid she has an appointment this morning in order to apply for a hardship loan because her universal credit has been cancelled. So she, I'm afraid, has prioritised that appointment.
You're quite right too. Well, I mean, I'm sure she's interested in the case, I'm sure, but...
Well, I wanted that to be clear, and of course, if we do go into tomorrow, and rather optimistic we won't, then she will of course attend tomorrow, but she does need my instructions.
But we wouldn't have taken it amiss even if she hadn't been, so don't worry about that. I'm glad what you just said. Our view, I think, is that this case really needn't go more than a day. But we'll see how we go.
Just by way of housekeeping, the court should have a hearing bundle which comprises a core bundle and a supplemental bundle. There's an agreed bundle of authorities and a perfected skeleton from each of us. There is also a slim further bundle from me, which was emailed last night. I'm afraid hard copies haven't quite yet reached the court this morning, and as soon as they arrive...
We do prefer, some of us anyway, prefer hard copies. So
they're on their way.
We can watch them on us. We have brought our screens into court, which we don't normally do, or I don't, my lord or my lady do, because one oddity about the case, which I'll just get off my chest, is there's quite a lot of important contemporary documents, not, the case doesn't turn on them, but to tell the story, which none of them were put in the supplementary bundle. And they're referred to in the skeletons, and they're referred to by the judge. We didn't have them, but so that's why I asked for the trial bundle. I think that your idea was it'd be enough for us to have a very full
well, that was
agreed chronology.
Below, we had one day. It was very expedited below, and my experience of taking the court through social care records is that it's a very laborious and slow process. And so the idea below was to have as full a chronology as possible that was agreed by the parties, in order to speed that process up.
I see. Well, I'm not really giving
that's caused any issue.
But we have. We'll just have to see how the argument goes. But when you refer to bits of the history, I think we would like to see the documents themselves, and we're in a position to do so electronically.
Well, that's noted. You may have to give me a moment or two in order to do the cross-referencing, but we can.
Well, we'll manage. We'll manage, I'm sure. Just 2 or 3 points by way of introduction, if I may.
I wanted to be clear at the outset of our appeal about the scope and purpose of it. And I do so just to pick up a couple of comments that have been made in the respondent skeleton to make.
One more thing before you start, Ms. Hannay. I'm obviously getting old and deaf. If you could just speak up a little, I'd be grateful.
I'm so sorry. I will endeavour
well,
to do
it
so.
happens to all of us. But,
I think my voice has a habit of dropping, so please, if that happens, please do remember.
I'll remind you from time to time. Okay, off you go.
So, my lord, just by way of opening observation, first of all, we accept, as we did below, that DF was never an eligible child because she was never accommodated by Essex. And as such, it follows inexorably that she is not and has never been a former relevant child. We say that the Section 20 duty in respect of DF arose or crystallised on, at the very latest, the 2nd of January 2023. We don't need to argue about the date before that because of what I'm about to say next. And that was when the notice to quit was served by Colchester Borough Homes, when it expired. And we say the failure at or around that date to accept that the Section 20 duty had arisen constitutes an error of law. The key dates are that DF then turned 18 on the 8th of April 2023. The 7th of January 2023 is the 13-week point before that. So in order to be a former relevant child upon her 18th birthday, she would have had to have been accommodated for 13 weeks prior to the 8th of April, which is the 7th of January. In the respondent skeleton...
In that 5-day window, she should have been accommodated, is your case?
At the latest, but I don't have to go behind that. On on a logical analysis of our case, in fact, the duty to accommodate her arose much earlier because she was a trespasser the moment effectively of her mother's death. But the point is that for these purposes today, the 2nd of January suffices. In the respondent's skeleton argument at paragraph 67, it said that we've abandoned the argument that DF...
So is this your first, are you still on your first point? Or so you said you had 3 introductory points.
This is a rather long introductory
Yeah,
first
no problem,
point.
just for my notes.
And then I
Yep.
have 2 much shorter ones after that. In the respondent's skeleton argument, it said that we should have accommodated her, that we've abandoned the argument that she should have been accommodated for 13 weeks. That in fact we're saying that Essex should only have accommodated her for 6 weeks, i.e. until the date on which in fact Colchester made an offer of accommodation. That's not right, that's a mischaracterisation of our case. We say what should have happened is that she should have been accommodated at least from the 2nd of January, which would have given her the 13 weeks and made her a former relevant child upon her 18th birthday. We say that if we're right that Essex made that error of law in not accommodating her in January, then she falls within the discretion described in GE Eritrea. And we say, we invite you in due course to find, the sole justifiable outcome is that Essex is required to exercise its discretion to treat DF as a former relevant child. But they're not with us on that. Alternatively, they must reconsider whether to exercise their discretion in the light of the court's findings as to the Section 20 duty. As to what assistance DF would obtain at this stage...
So just pausing there just for clarification. The judge refers to what I think he says is common ground, but I may have misremembered this, that even apart from the GE Eritrea discretion, there's a yet further residual discretion. You haven't mentioned that.
No, I was going to come on to that because that was my second introductory point.
Oh, right.
And I was going to say, I'll rather than have a cliffhanger.
I can wait.
You can wait. I'm very grateful. Just as to what assistance DF may obtain at this stage, by being treated as if she were a former relevant child by Essex, she happily now has accommodation provided by Colchester Borough Council, so does not need that to be provided by the Social Services Authority. She did explain in her witness statement below, and this remains the position, that she would like help maintaining that accommodation, support from a personal advisor, help with budgeting,
Oh, okay.
and help with securing further education and training. And the reference for that is paragraphs 29 to 31 of her witness statement, supplementary bundle 17. And we say those are things that would be of conspicuous importance to DF and assist her to continue her transition into adulthood.
And are those not forms of support that might be available from social services to an adult in her position?
Well, no, she wouldn't meet any of the criteria. So if she was in respect of adult social care, that would ordinarily fall for individuals who are disabled or had some other specific characteristics. And as far as we are concerned, certainly she wouldn't meet the criteria to be provided with those kinds of support by Essex. I can take instruction certainly whether she has applied. I don't understand that to be the case. Back to my second introductory point. We don't today on reflection pursue ground 5. That is the residual discretion point. And just to be clear, that is on the basis that if we are right on any of grounds 1 to 4, then either because the court orders that she must be treated as if she were a former relevant child, or because the court sends it back for reconsideration. Essex is one way or the other going to have to look at this again.
Yeah.
We accept that ground 5 in the light of that is not to be pursued today. Those are my introductory observations. Just by way of structure of my submissions and where I'm going, I'm going to very straightforwardly deal with the grounds in turn. The only deviation from that is between dealing with ground 1 and ground 2. I propose to deal with the respondents' overview points set out in their skeleton argument at 47 to 50, because those are said to apply to grounds 2 to 4. I don't propose to take the court through the factual background, save for when it arises in relevance to each of the grounds, and ditto as to the legal principles. Those are set out in the judge's judgment. I will take the court briefly to the relevant legislative provisions and some relevant cases, but I don't propose to set out the general framework, unless the court indicates otherwise.
No,
I'm
that
getting
sounds, if I may
nods,
say so, just what we would like.
Before I start, the authorities bundles have arrived. May I just turn
Of course,
and
yes.
have this passed up?
But why don't we have it now? Hopefully, I shall kindly bring it up.
Thank you. And just to be clear, that's the bundle that was emailed last night. So it's the same bundle, just in hard copy form.
Thank you. So, my lady, turning then to ground 1, the judge below was wrong to find that a homeless child does not necessarily require accommodation. As we note in our skeleton argument of paragraph 7, the judge held that DF was a trespasser of the property, and from the 2nd of January 2023 at least, was homeless within the meaning of section 175 of the Housing Act. Those are not findings that are challenged by the respondent. If I may summarise our submissions on this ground before I turn to the relevant legislative provisions in the cases that I say make good those propositions, they're as follows. First, the question raised by this ground of appeal is whether a child can be homeless for the purposes of housing legislation and yet not require accommodation under the Children Act. And we say that if the two legislative regimes, i.e. the Housing Act and the Children Act, are to work as Parliament intended, and in the manner that the House of Lords in G and Southwark said that they fit together, we say the answer to that question must be no. We say second, the case law is clear, and that this is reflected in the statutory guidance, that the duty in section 20 takes precedence over the homelessness duties in the Housing Act for 16 to 17-year-olds. And that Parliament intended for children and young people aged 16 to 17 to generally be cared for by social care and not by housing. There are some exceptions to that principle, but I'll come back to those. Third, although they are in separate statutes, Parliament must have intended section 175 of the Housing Act 1996 and section 20 to work together, or as we put it in the skeleton, to be interlinked. Children who are owed a duty under section 20 are taken out of priority need under the housing legislation, although in certain defined circumstances they are put back in. That's the exception rather than the norm. And we say that the two statutory regimes therefore must be interpreted consistently and by reference to one another. Fourth, the conclusion in this case that DF was homeless as at the 2nd of January 2023 would mean necessarily that the Housing Authority owed her a duty to provide accommodation under the housing legislation. So you just have that proposition again?
Because she was homeless, I could add in also eligible for assistance and in priority need if she wasn't owed a section 20 duty, that the Housing Authority owed her a duty to provide accommodation as at the 2nd of January. Yet on the judge's analysis, she didn't require accommodation for the purpose of section 20. And we say that is precisely what the House of Lords in Southwark, and indeed the statutory guidance, say quite clearly is not supposed to happen. We say that if the primacy of section 20 duty is to work, the meaning of requires accommodation in section 20 has to dovetail with the meaning of homelessness in the Housing Act. And it must include children who are homeless within the meaning of section 175. Now, that doesn't mean that a section 20 duty necessarily arises in respect of all homeless children. For example, the child must also require accommodation for one of the reasons in section 21. Similarly, a child who's been properly advised and has the capacity to reach that decision may decide that they do not want to be accommodated under section 20.
Sorry, there's 2 points. Is that first has to satisfy one of the conditions in subsection 1. We're not concerned with subsection 3 for this purpose, are we?
No.
And the second point was that the child can still say no.
Yes.
Those are
If
two,
they're 16
I got
or
that right.
17.
Those are 2 separate points.
Yes, if they're 16 or 17 and they have been properly advised and they have capacity, they may decline to receive accommodation under section 20. So we're really focusing on the meaning of requires accommodation in section 20, and those things that have to dovetail. It doesn't necessarily answer the totality of the section 20 inquiry, but that's the focus of this ground of appeal. So that really is our submissions in a nutshell. And in order to make good those points, I propose to do 4 things. First of all, just show the court the relevant legislative provisions. I'll try and do that with a fairly light touch. Take the court to the decision of the House of Lords in Southwark. There are a trio of House of Lords cases that are relevant here. Southwark, Barnet and Hammersmith. But Barnet and Hammersmith, which are the earlier decisions, are very well summarised in Southwark, and I can do the job, I think, by just showing you Southwark. That's the second thing. Third, just take the court to what the judge said on this point, and finally deal with the points against me in my low friend's skeleton argument. So this is the structure of my submissions for ground 1.
Thank you.
So dealing with the legislative provisions then, let me start by turning up the main bundle of authorities. And section 20, which is authority tab 5, page 25. Section 20, subsection 1 is set out there. Every local authority shall provide accommodation for any child in need within their area who appears to them to require accommodation as a result of. And then there are 3 circumstances set out. Child in need receives definition in section 17, subsection 10 on page 21 of the bundle. I do propose to go through that on the basis that in this case DF was accepted as being a child in need. Just a couple of observations about section 21 while we're here. The language is, it has to appear to the local authority. In AB and Brent, which is in the authorities bundle, tab 33 at 554, I'll take the call back to it later. Mr. Justice Poole held that this was not a particularly high threshold to appear to the local authority.
What does I don't understand what that means.
It means that local authority doesn't have to be satisfied or sure. It merely needs to appear to the local authority.
Oh. Okay.
As Brown as Hale held in Southwark, and again I'll take you to that in a moment, it's an evaluative judgment, those elements. So whether or not a child is in need, and whether or not the child appears to them to require accommodation, indeed for one of the reasons set out. But once those elements are satisfied, there isn't a discretion about whether or not to provide the accommodation. I'll show you that bit of Southwark in a moment. Part of the assessment of whether a child requires accommodation will include an evaluation of the suitability of any accommodation that they presently possess.
Shall I say it again?
Part of determining whether a child requires accommodation will require a local authority to evaluate or assess any accommodation the child already possesses. And there's authority, again I'll take you to this when we get to ground 4, that where accommodation is precarious because of its uncertain nature or temporary state, that may well mean that the child requires accommodation. In other words, having a roof over one's head doesn't necessarily satisfy the test of requires accommodation. Again, we'll return to that at ground 4. And as I've already indicated in the introductory remarks, the requiring of accommodation is linked to, or must be as a result of, one of the reasons that are set out in the in section 20, subsection 1. Well, just to flag while we're here, subsection 26, you'll recall when we, in the introductory remarks, I pointed out that not all homeless children will require section 20 accommodation, because those who are able to have capacity to make that decision, who have been well informed, they decide not to. And you'll see it's subsection 6, the requirement that the local authority shall far as is reasonably practicable, ascertain the child's wishes, and give due consideration having regard to his age and understanding such wishes and feelings.
Sorry, did you say that was section 26?
Section 20, subsection 6. I'm so sorry, my lady.
Sound familiar?
Subsection 6, 20, subsection 6. And the provisions that follow after subsection 6 make it clear that section 20 is a duty that requires either the permission of the parents or the consent of the parents, or so sorry, what's the reference? Subsection subsection 11, or the consent of the child themselves. So it's not a coercive regime. It's premised on the consent of either the person with parental responsibility for the child or the consent of the child themselves if they're 16 or 17.
So theoretically, and it had to be a very extreme case, if a child was perhaps, to make it less, so the child of 17 years and 10 months was, sleeping in a shelter on the street and appeared to know exactly what they were doing and wanted to do it, they couldn't be forced into accommodation.
No.
Yeah. I mean, they might, on the circumstances, be put into care, but
the more usual way that it transpires is that a child who is 16 or 17 is found to require accommodation. He or she is offered type of accommodation to section 20 that may be perhaps slightly more restrictive,
right,
or provides less freedom perhaps than that individual child wishes to have, for example, foster care, so on. And in those circumstances, the child can, if it is explained to them what the difference between section 20 and all of the wraparound that comes with section 20 and provision of housing under the Housing Act, they can be referred to housing authority to provide accommodation by them.
Yeah, okay.
And I'll take, that's quite well explained actually in the statutory guidance, and I'll take you to that in a moment. Section 22 is on page 28. This sets out the general duties of the local authority in relation to children who are looked after by them. And you'll see that looked after is defined in subsection 1 as being a reference to a child who's in their care. that's subject to a care order. Subsection B, provided with accommodation by the authority in the exercise of any functions under this legislation. So in other words, that captures section 20 accommodation, so a child who is provided with accommodation in section 20 is looked after. You can see subsection 3, the duties of the local authority with respect to looking after who are looking after a child. So duty to safeguard and promote its welfare.
Sorry, I'm being slow. B, provided accommodation by the authority in the exercise of any functions. So I see that would include section 20.
It includes section 20, yes. It does exclude certain functions under the Children Act.
So I
but
see,
don't
no,
need
that's
to worry
fine,
about
thank
that.
you.
So subsection 3 sets out the general duties. And you can see over the page at section 22B, which is on page 31, there's also a duty of maintenance of a looked after child. Section 22C sets out the ways in which looked after children are to be accommodated and maintained. But I don't propose to dwell on this for a long time because, of course, we never quite got to this stage. But there are that sets out the manner in which children should be accommodated. It sets out a hierarchy, effectively either with a parent or, if not, a hierarchy of placements that are set out in subsection 6. Preferably with an individual who's a relative or friend, and so on and so forth. So the reason I flag this is it just shows quite starkly the contrast with the housing duties, where, of course, generally speaking, that will be discharged by way of provision of accommodation only. Well, I don't propose to go through the ways in which children enter the looked after regime after they turn 18, because that's quite well set out in the judgment and been set out in the skeleton arguments below. Suffice to say that the duties that are owed to a former relevant child after the age of 18 are extensive and significant, and they are intended to replicate the kind of care that a parent would provide to an 18 or 19-year-old child, slightly older. And you can see they are set out in section 23C, which is at page 40. And things like, for example, at subsection 2, keeping in touch. Section 3, doing an appointment of a personal advisor, keeping a pathway plan under review, and then in 4, assistance of the kind referred to in section 24.3.1, which you can see is over the page. It's really assistance with employment, education and training, and other assistance to the extent his welfare requires it, and that can include accommodation. And these duties persist to the age of 21, or in certain circumstances, if the child remains in, the young person remains in education training to 25. So it's a very significant level of support that's contemplated. Now, the Housing Act, well, I've done that of a very
An
light
oddity of the
touch.
system, I suppose, is that suppose they're deprived of their parent a day after their 18th birthday. It's just that then no such provision is available.
That's right, and also if you're looked after for less than 13 weeks before your 18th birthday. The legislation, I surmise, tracks 13 weeks of being looked after as being a point at which you fall within the category of child for whom an additional level of support is contemplated after 18.
Well, it's what used to be regarded as the leaving care provisions, isn't it? It was because there was a dreadful state of affairs where children, very often who'd been in long-term foster care or in residential accommodation at 16, were packed off into some less than satisfactory, if I can put it like that, bedsit, to fly on their own.
Indeed.
And these provisions were put in place to give them a safe landing.
Indeed, Manuel, but it is true that there are some hard lines drawn within the legislation, since the one does have to have had 13 weeks.
Exactly, that's because it's leaving care provisions.
Indeed.
It's not designed for people who may have a very difficult background,
Yes,
but have not been in care.
yes. Indeed.
Would you say that the judge or this court would be entitled to take into account that philosophy in circumstances where actually your lay client wasn't asking for accommodation? What she's asking for was a gateway into these provisions.
Well,
Asking to be in care.
well, can I unpack that? There's several points I think in there that I need to deal with. She wasn't in care at the time she turned 18. That is undoubtedly correct. Our submission is that she should have been. She should have been from
In
2nd
order
of
to
January.
facilitate her to get these provisions. That was why she wanted. If she should have been in care, that would have been the purpose of it.
Well,
Because it wasn't to provide her with accommodation.
well,
Am I wrong about that?
well, I think she did have accommodation. I'll come back to that, no doubt, some detail in a moment. But we, of course, said that that wasn't suitable accommodation, or she required accommodation because that accommodation was precarious or uncertain and so on and so forth. She also required the other matters that came with accommodation, so the types of care that is also contemplated by Section 20. The reason why she was asking for those things, I'm not sure that means that she's not then eligible to receive them after the age of 18, maybe. In the sense that if she was owed a duty under Section 20 as of January, then particular reasons that she was asking for that duty to be owed seem to be not, in respect, not to the point, because ultimately we say she should have been accommodated in January, and that should have given her 13 weeks. That should have entitled her to the leaving care provisions thereafter, because, as Parliament intended, if one is in care for 13 weeks, that is the gateway into the leaving care provisions.
But if the child is not in fact in care, if I got it right, you said there are some hard lines. Case 1, child loses her parent the day after her 18th birthday, nothing. Case 2, child loses her mother when the child is 17 3/4, less than 13 weeks to go before her 18th birthday. It'd still be nothing.
Yes.
Case 3, child loses her parent at 17 and a half or 17 years, 8 months. You say that the Section 20 duty kicks in, and it means that after she turns 18, she should be treated as a former relevant child for the 3 years up to her 21st birthday.
Just dig that last question, just so I understand. Just so I check I understand the.
So can you speak up a little?
Just so I can check that I understand the question that's being
Yeah.
put. You were asking me that if her parent dies at a point at which she can achieve the 13 weeks
Yes.
before her 18th birthday,
Yeah.
she would then be eligible for leaving care provisions, and the answer to that is yes. Can I just tweak that slightly? Of course, this is a case in which we accept that she was never in fact provided with care, and so
Yeah.
never became an eligible child. So she falls into the category of children for whom we don't have an automatic entitlement to the former relevant children category. She is not a former relevant child, but there is that regime under GE Eritrea whereby for children who, where there has been a relevant error for children, broadly cases really where for whatever reason the child should have been treated as being looked after but wasn't because of some error or mistake by the local authority, that there is a residual discretion in the local authority to treat them as if they were a former relevant child. And that's the category that we fall in. Because if she had been accommodated, when we say she should have been accommodated, she should have had the 13 weeks and then come out the other end.
She
Short
should have been
terms on
acco-
require accommodation.
Yes, exactly.
Yeah.
Drives us straight back to that point. Yes.
When you say she should have been accommodated, where?
Well, that there are a variety of possibilities. The housing authority, for example, suggested that she stayed, say, whether she was, and that the social services authority paid the
Sorry,
rent.
I'm sorry to be
So-
tricky, but you are dropping your voice all the time. She should have
One
been.
possibility is that she could have stayed in her own house, but with the additional care and support that came in under Section 20.
Just not with that. You said a moment ago that the local authority paid the rent, but I don't know how that would work because she couldn't be a tenant because she was under 18. So what would have happened?
Well,
The local authority would have had to become a tenant and give her a licence.
Well,
Has that ever happened?
The Colchester was suggesting that was one of the suggestions in the.
But was that ever a practical suggestion? Could that have happened?
It was never explored, my lady. I simply don't know. It was Colchester were suggesting it. So
couldn't be a tenant, could she?
no, I accept that. Accept that entirely.
So there would have had to be a tenant.
Well, I mean, there was a short period where no doubt some accommodation could have been made, whether that was a licence, a contractual licence, or some other mechanism. But that was certainly a suggestion from the housing authority. So it was never
Will
pursued
you
by-
show us that in due course? Yeah, okay.
Of course. There were other accommodation options discussed, Melanie, but of course none of those were ever crystallised, none of them were ever.
But none of them, your Lakeline didn't want any of them.
Well,
She didn't want to go into foster care. She couldn't have her boyfriend and her cats in
Well,
foster care. Understandably, of course she didn't want to go into foster care.
Melanie, the judge found that actually the claimant actually never refused any of those options, and none of those ever came to a point of crystallising, because before it came to the crunch, if you like,
Got what she wanted.
Colchester offered her a
independent
flat.
accommodation.
Yes.
Which of course is what she wanted. How could she have wanted anything else?
Well, my lady, that's right, but she did also want the support that came with Section 20, and that's quite clear from her witness statement with respect, and it's quite apparent from her lack of accommodation, lack of employment and training, difficulties in managing money, all of
I
the
understand, I've read her statement.
the chaotic matters that formed her life at that time, and instructions continue to do so, that she did want to be accommodated under Section 20, and she was expressing that wish. So
You'll take us to that. I think I've missed that. I've missed an identifiable specific statement by her that she wished to be accommodated.
So, Melody, we do say that there are ways in which a Section 20 duty could have been discharged. It never got to that point, frankly, and that's the difficulty in this case, that time moved on. But the question is, did the Section 20 duty crystallise in January? We say it did, because at that point she required accommodation.
But on this question of, you say she could have stayed in her own house. Am I remembering wrongly that this was a point for which you didn't get permission?
No, that was ground
Initially-
6, Mel. That was to do with the
I don't
point
know, I
about
don't mean
living
permission
with-
here, I mean permission below. Permission to apply for judicial review. I may have misremembered that.
I have to check that. I'll ask my junior. It's not ringing a bell, but I may not have picked that point up.
Well, it's quite likely I've misremembered it, but
I'll check that.
Mr. Alban will tell us if there's an issue there. Yep, okay.
Can I just go back to the legislation and take you to the housing legislation, which is in tab 6, page 50. Sets out definition of homelessness. Subsection 1, person who's homeless has no accommodation available for his occupation, which he's entitled to occupy by virtue of interest, etc., has an express or implied licence, or occupies as a residence by virtue of any enactment or rule of law, giving him the right to remain in occupation, restricting the right of the person to recover possession. Subsection 3, a person shall not be treated as having occupation as his accommodation which would be reasonable for him to continue to occupy. And subsection 4, threatened with homelessness. The remaining provisions set out behind that, section 185 sets out when a person won't be eligible for housing assistance. That's not DF because she's not somebody who's subject to immigration control.
Well, I mean, there's no issue now with the ones below that she was at material times homeless. That doesn't mean there may not be provisions you want to take us to, but
Can I just show you 17194, which is at page 193 on page 60, which is just when the duty to provide accommodation for the housing legislation crystallises, satisfy they're homeless, satisfy they have a priority need.
sorry, where are you reading from?
I'm sorry, section 193, subsection 1, page 60.
Yes.
It sets out the criteria
Yes,
by
I see.
which must be met, and you'll see at subsection 2, shall secure that accommodation is available. The references to 189B are to a duty to try to secure accommodation that lasts for about 8 weeks. It's not relevant here, but those are the criteria that she had to meet in order to be eligible for housing assistance. And we say that once she was homeless, she was effectively meeting those criteria. Over the page on page 73 is the homelessness priority need order.
Just before we leave it behind us, Hannah, can you help me with this? You showed us 175, which has one concept, homelessness, and another subsection called threatened with homelessness. Where does threatened with homelessness get picked up? If you're threatened with homelessness, what other duties kick in?
No, just tell me about 1 second, just have a check. Right. That's what I'm looking at. It's I don't think it's in our bundle, which is why I was just double checking. It's that the housing authority has to take reasonable steps to help secure accommodation, and then of course when that person then becomes homeless, then the main duty under section 175 would kick in, as it were.
Thank you.
Priority need order, and that's my lady, is at page 73. And I should have said it. This was enacted after the 1996 Act. There isn't any. The definition of priority need in the legislation itself doesn't include young people. Priority need, regulation 2, descriptions of persons.
Sorry, just so we have a note for this, the order is made under what? There's a power somewhere in the primary statute, what, to define priority need? Or
Yes, I'm so sorry. I skipped over it because I sort of sped up a little bit. It's 189, page 58, subsection 2. Empowers the Secretary of State to specify further descriptions of those in priority
So
need.
189(1) it doesn't include being a child as such.
No,
Yeah, okay. That was the point you were making.
exactly. There are ways, I suppose, that one might have fell within it, but there's no clear, sharp-edged priority need for children. So this is the regulations made under that paragraph,
Yeah,
page
thank you.
73. Regulation 2, descriptions of persons specified in the following articles have a priority need. And then over page 74, children aged 16 or 17. This then covers a person other than a person to whom paragraph 2 below applies. Age 16 or 17 who's not a relevant child for purposes of section 23A of the Children Act. Just pausing there, someone who's a relevant child for purposes of section 23A is someone to whom the local authority owes a separate duty to accommodate.
What do you mean by separate duty? Separate from what?
Separate from section 20. It's a discrete duty. It's for the slightly odd category of those who have, I'm not sure I've ever seen it arise on a set of facts, but no doubt the lady will correct me if I'm wrong, but someone has been in care 13 weeks, stops being in care. And there's a duty to provide accommodation for them.
Okay.
I don't think it matters for our purposes, but it's,
No, fine,
it's a
that's
category
helpful.
for whom another social services or duty is owed effectively. And then paragraph 2,
Hang on 1 second. Where's the verb in
it's a very
paragraph
hard
1?
regulation to read. One has to read it a
Person?
few
If
times.
we ignore the
It's-
brackets. A person aged 16 or 17 who's not a relevant child.
And you can stop because that last bit applies to Wales. So you
So
can.
it's a sentence without a verb.
Look, if I insist, it's a list. That's why it doesn't have a verb. It's a
Oh,
list.
I see. It's a list. How silly of me. Yes, I see. Of course.
Thank you.
Um,
Yes, and one gets that from the previous page. The description of person specified in the following articles.
so yes, I see. So it's effectively ignoring the exclusions within it. It's anyone aged 16 or 17 comes under 1,
Exactly.
and then 2.
Disapplies effectively a person to whom a duty is owed under section 20. So,
Yes, I see.
I mean, just to put it in as simple as possible terms, if you're aged 16 or 17, you have a priority need for accommodation unless you're owed a duty by the Social Services Authority, either because you're a relevant child or because you are owed a duty under section 20 of the 1989 Act.
Yeah.
It does take one or two readings in order
It does, doesn't it?
to get one's mind around it. Right, so those are the key legislative provisions. May I just show you the guidance for prevention of homelessness and provision of accommodation for 16 and 17-year-olds. That's at tab 11, page 91. Joint guidance promulgated at the time by the Ministry of Housing, Department of Education. There are a number of definitions on page 95.
Just before we get there, what's the status of this guidance?
Can I take you to that in just a moment?
Oh, sorry, yeah.
That's on, it is dealt with at pages 96 and
I
97.
see, fine, no problem.
The definitions are on page 95. In particular, homeless refers, in relation to housing services, refers to section 175 of the Housing Act, requiring accommodation. In relation to children's services, refers to section 20 of the Children Act. And then over the page on page 96, you can see in paragraph 1.1 that the joint guidance was first published following a number of judgments handed down by the House of Lords. So in other words, it's intended to replicate the guidance given in those judgments. You see paragraph 1.2 makes further reference to that case law. So just ask you to read that.
All right, I'd rather read the cases, but still, what
Okay,
you
so I'm
say
gonna
you
go
say you
next.
did want us to read it.
Yes, please. It's relatively short. It's really the precedence point that I'm keen to.
Yes, okay. Let me just read it.
So it was updated to reflect the 2017 Act. Are there any proposals or is there an update in the pipeline in the light of the introduction of the can only place in regulated accommodation?
I'm not aware of any, lady.
So it's effectively significantly out of date. This guidance.
It's my junior tells me that there is separate guidance on that, although we're not sure. We'd have to check if there's statutory guidance in respect of that. It is. I take the point that it is.
And if there's guidance, we haven't got that guidance that applies to regulated, or have we?
No, it's not before the court. Well, Melody, at the time this appeal took place, it was before the bringing into force of the requirements.
Understood, but it was anticipated it was coming into force.
It was anticipated. It was certainly anticipated at that point. Although I think it was before there was a certainty as to precisely when. I'd have to go back and check the chronology.
But it was known. But please correct me if I'm wrong.
It was-
I'm
must-
asking the question, not
Melody, it was most certainly known because that was, of course, a point taken into account by the judge. Yes.
And it's not part of your grounds of appeal to say that the judge was wrong in taking that anticipated change to the legislation into account.
It was part of the grounds in the sense that formed part of ground 6 in relation to
For which I haven't got permission.
which was held to be academic, because of course, as it was never decided, or as no Section 20 duty was ever accepted by the local authority, we never got to the point of how that might be fully discharged.
Well, we can no doubt see when by the parts that you refer to in the guidance whether or not that's impacted.
Yes, but I take that point. The points I think for the most part that I rely on really come from, I don't think would be affected by the change in the
All right,
law.
thank you.
Paragraph 1.3, Section 20 duty, Section 20 Act duty takes, sorry, Section 20 of the Children Act duty takes precedence. And then my lord asked me about the status of the guidance that's set out in paragraph 1.6. So it's statutory guidance issued both jointly under the Local Authorities Social Services Act and under Section 182 of the Housing Act. And we've included Section 182 of the Housing Act in that clip of authorities that we handed up this morning.
Hang on 1 second. So the formulation with which we're strictly speaking concerned, that we're dealing with local authorities, is to act under the general guidance unless there are exceptional reasons in individual case authorities are expected to comply with this guidance. I see. Have we got Section 7 of the 1970 Act? In that?
Yes, you do. That's in tab 1.
That one. Thank you.
So my lord, then just, where's my lady, picking up other relevant provisions. Paragraphs 3.1, 3.2 on page 100. You see that those provisions really presuppose that homeless children will require accommodation.
So say it again.
Paragraphs 3.1 to 3.2.
Yeah. What was the proposition you then got from?
That those provisions assume or presuppose that homeless children will require
Where does it say that?
accommodation.
Sorry, I may have misunderstood. I thought you were quoting, saying that the provisions
This is
assume. You mean the paragraphs of the guidance assume?
Yes, exactly.
Yes, I see.
Exactly. Then paragraphs 3.13, which forms the basis for ground 2.
Sorry, 3.13.
Yes, on page 102.
You mean 3.13?
Yes.
Yeah, sorry.
So it's two circumstances in which a local authority might find that a homeless young person should not be accommodated under Section 20, may instead be home duties under the Housing Act. They're where the person is not a child in need, or is 16 or 17, having been properly and fully advised, etc. That's the category that I've already alluded to.
Yes, but that's on the assumption that they are people who otherwise require accommodation.
Yes.
So this doesn't really get you any further, does it?
Well, it's the references to a homeless young person. And I've taken you to the definition, which is that a homeless young person is a person who's homeless for purposes of the Act, of the Housing Act. So we say that does contemplate a young child, a person, child or young person is homeless, i.e., that they require accommodation under the Housing Act, that in those circumstances they will require accommodation in Section 20.
So this would, but the guidance can't override
No,
what
no.
would otherwise be the statutory requirement.
No, I don't suggest that. I'm saying it is supportive of our position. that where a child or young person is homeless, that he or she necessarily
But
requires accommodation under the
In the
Act.
normal case, that will follow.
Yes,
The problem, we have an unusual case here.
we do. Well, I quite accept that. Quite accept that this is not a usual case. And then finally, can I just flag paragraphs 3.2.3. We need to determine first if the young person is actually homeless. And
What did you mean 323?
Sorry.
I'm not
Yes.
being picky.
No,
I
no,
just
I'm-
there is such a thing as 3.2.3, and that's what really meant.
I'm trying to concentrate on too many things at
Could
the
have
same time. 3.23, yes.
Yeah.
And 3.28 is the other point I wanted to flag. Just for the purpose that obviously that the way that the guidance contemplates is that a child presents as homeless and an assessment is undertaken whereby decisions must be made in the result as a result of that assessment.
I'm slightly struggling with this because there seems to be an introduction of a term of art which may be different from the statutory definition of homelessness. Because when we look at 3.2, that is 3.2,
Yes.
it says, whereas if there is an imminent threat of homelessness, or if the young person is actually homeless, and then again, when we've taken us just to 3.23, the most crucial issue to be determined in the first instance will be whether the young person is actually homeless. And I'm just not clear whether or not, you know, if that wasn't supposed to be something different from technical homelessness, which is what we have in our case, because fortunately, thankfully, she wasn't actually on the street. But why is the word actually there? And when it's in association with imminent threat, and the fact that section 20 is usually something that happens urgently, actually homeless different from technical homelessness? Because it seems to suggest it might be.
Sorry, Melanie, which would you remind me which paragraph you're
Sorry.
in? Sorry.
3.2.
3.2.
Final 4 lines. Whereas if there is an imminent threat of homelessness, or if the young person is actually homeless. And then again, we have the same at 3.23, the introduction of it's a crucial issue to be determined in the first instance with whether the young person is actually homeless. I mean, it's a sort of urgency that ties in with my experience of what section 20 is more usually used.
Melanie, I mean, all I can say is that obviously one goes back to the definition, and perhaps that's just seeking to distinguish between
what I'm trying to grapple with, and maybe there isn't an answer, and I'm perhaps being too nitpicking, but what I'm trying to work out in my mind is whether or not there's a distinction being drawn there from a practical point of view between what can be technical homelessness, which is what actually we have in this case, because fortunately, as I've said, this young girl wasn't on the streets, and an urgency being imposed upon the local authority where they are actually homeless or in an imminent threat of being actually homeless. And I'm just looking at the guidance, because if there is that differentiation, otherwise why would you put the word actually in? Because we all know you're not supposed to add a gloss to definitions, statutory definitions. Doesn't that impact upon the use of the guidance in cases?
well, isn't this paragraph seeking to differentiate the types of support that may be appropriately given? And so that paragraph, no immediate threat of homelessness, so going back, that then goes on to set out the type of intervention that might be most appropriately put in place, i.e. early help services, presumably to try to ensure that the homelessness does not itself materialise. Whereas the second half of that sentence is saying, well, if there's an imminent threat of homelessness, or the actual person is actually homeless, i.e. homeless within the definition, I would say, the definition in the statute, in the guidance itself, then the response is different. As I understand that, I appreciate it is statutory guidance, one has to be a little careful, and I take that point. That is seeking to draw the distinction between those different types of homelessness.
Takes me back to my pupil master who never let me draft anything with the word ly, with a word ending in ly in it.
It's very
It was
undoubtedly
sage
good
advice.
Undoubtedly so. So that's the statutory guidance. May I please now just show you Southwark, which, as I indicated earlier, is the third of a trio of House of Lords authorities. It's at tab 20, page 314. As I said, the previous decisions of Barnett and Hammersmith are, to a large extent, relevant. It's extracted by Baroness Hale in the judgment in Southwark. The issue is set out by Baroness Hale on paragraph 3 on page 316. And point being that if a child, she said, who's been thrown out of the family home presents himself to a local children's services authority and asks to be accommodated by them under section 20, is open to that authority and said to arrange for him to be accommodated by the local housing authority. At paragraph 5, she expresses some surprise that the issue has come before the court, given the observations that she made in Hammersmith, which is alluded to. In that case, the child had approached the housing authority and asked them to accommodate her, and the House made it clear that she should not have been referred to. So the House made it clear that she should have been referred to the Children's Authority for assessment, and it was not contemplated that had she been assessed as falling in the criteria, she might nevertheless have been referred back to the Housing Department.
So where are you reading from?
I'm reading at the top of page 317, paragraph 5.
Yes, I see. Thank you, and I found it. Thank you, yeah.
And then there's an extract from the judgment just above paragraph 6, that the clear intention of the legislation and so on. So I just invite you to read that.
Just for my education, in this particular case, the housing authority and the local authority with social services responsibility are different authorities.
Yes,
Presumably that is sometimes the case and sometimes isn't.
that's right. So in London, I immediately recall, it is dealt with, I think, perhaps in Hammersmith, but in certain authorities they will be the same authority. So, for example, in London authority, generally they're the same.
Yes.
But certainly outside of London, where one has a county council and a district
Yes,
council.
no, that's fine. I just
This is
wanted
a
to make
borough
sure I hadn't
council, in which case
misunderstood.
they're
Yep,
actually coterminous.
that's fine. But the problem can arise even if it's a single legal person, a single authority, because you will have different functions governed by
Indeed.
different regimes.
That's right, and certainly in both Hammersmith and in Southwark, they were the housing authority and the social services authority were coterminous.
They were the same body.
Indeed.
Yeah.
Yes, but one of the considerations in Hammersmith was that one can't treat the accommodation provided by the housing authority as having been provided by the social services authority, because of course in many cases they may not even be the same body. They
exactly.
were in Hammersmith.
Yeah,
wouldn't
okay,
necessarily be so in other cases.
I understand. That's very helpful.
She then sets out at paragraph 6 that neither the factual nor the legal problem is likely to arise before 2002, because before that there was little prospect of a 16 to 17-year-old being independently accommodated under the homelessness legislation. And then she sets out the priority need provisions that I've just taken you to, and notes that the priority need order is now expressly included children aged 16 and 17. And then again, she sets out an extract from Hammersmith and Fulham. Perhaps I'll just ask you to read that. It's a letter between letters E and F on page 317.
So sorry, I was just making a note. What you asked us to read?
The extract from Hammersmith, it's just below letter E.
Got it. Yes, thank you. I'm reading that. Yeah.
Paragraph 8, she describes the leaving care provisions. And over the page, at page 318, letter B, states that the general aim of these new responsibilities was to provide a child or young person with the sort of parental guidance and support which most young people growing up in their own families can take for granted, but which those who are separated or estranged from their families cannot. It's a rather more eloquently put away version of what I attempted to explain to you earlier. She sets out the facts of paragraph 12 and on, but broadly, G, the child in this case, was kicked out of his house by his mother and was what was described as sofa surfing, i.e. sleeping on friends' sofas or in cars. He attended at social services and was provided with accommodation by the local authority. The local authority in this case contended that that was provided under the Housing Act.
So this is when he was 17, yeah.
Therefore, he hadn't been looked after, and therefore the leaving care duties did not apply to him upon him attaining the age of 18. Paragraph 22, page 321, a discussion, which summarises extracts from Barnett there. Can I just ask you to look at paragraphs 24 and 25? Perhaps encapsulating the bits of Barnett that are relevant for our purposes.
Yes.
And then paragraph 26 discusses the 2002 order.
Just let me read that.
Yes, please.
Yes.
28 over the page on 323. She effectively pulls section 20 apart and sets out the relevant criteria that a child has to meet in order for the duty to arise. She deals with child in need at little 2. Perhaps you just read number 2, though it's not in dispute in this case that DF was a child in need. It does set out some of the relevant factors that may arise later.
Sorry, I'm where are you
So
asking?
sorry, I'm in paragraph 28.
I've got there, yeah.
Subparagraph 2.
Yes.
It's just below letter C, and it runs down to just about letter G.
Who wants us to read subparagraph 2? Yes.
And then at 4, she deals with the question, does he appear to the local authority to require accommodation?
Yeah.
And I just flag, I don't invite you to read it now, but just perhaps for your note, subparagraph 5, she sets out the different factors and explains how they apply. And at subparagraph 6, makes the point that I've already made, that section 20 doesn't operate as a coercive jurisdiction, as it were, against 16 and 17-year-olds. I don't invite you to read that now, but I just flag that explanation is given
Thank
there.
you.
In paragraph 29, she notes, just between letters D and E, observations of the Secretary of State that, in blunt terms, the local Children's Services Authority cannot refer a homeless child in need to the local housing authority. I'm so sorry, I just missed a little bit above that I probably should take you to, which is just her conclusions on the facts on this case, which is just between C and D. You can see halfway through that paragraph, it follows, therefore, that every item on the list have been assessed in Lay's favour. The duty and arisen in the authority was entitled to sidestep that duty by giving the accommodation a different label. And then finally, just at paragraph 31 of Baroness Hale's judgment, she makes the point, the very last sentence, that section 20 involves an evaluative judgment on some matters, but it's not a discretion. In other words, if the evaluation falls in the favour of the child, that gives rise to a duty rather than a discretion. Let me just show you the concurring judgment of Lord Newburgh, which starts on page 327. Makes observations about the relationship between the priority priority need order and the Act. He sets out the case for the local authority at paragraph 37, namely that the Children's Authority could perform its duty by making arrangements with the Housing Authority. And then he says in paragraph 38 that's inconsistent with Hammersmith, and that the 2002 order expressly excludes from priority those children aged 16 or 17. And he notes that the argument could not have been advanced before the 2002 order came into force. And then at 40, he notes that that argument is both circular but inconsistent with the reasoning, inconsistent with the purpose of the 2002 order. As if I could just invite you to read paragraph 40. Well, that's the one authority I wanted to show you on this point, but as I say, that also reflects decisions in Hammersmith and in Barnet. Can I just now turn to the judge's consideration at this point? So I'm on.
Leave this case. Speaking for myself, perhaps I haven't fully understood it, but it doesn't seem to me to help you very much. I mean, Bean's law states that a reported case is always easier than the one is hearing. And this seems to me to be an illustration. Paragraph 28(4 of Lady Hale's speech, she says it's perfectly obvious that a safer surfing 16 or 17-year-old, quote, requires accommodation. The critical question for us is whether your client, quote, required accommodation. It's not as obvious as in this case.
I accept that, of course, each of these cases, and they all have very specific facts, and I entirely acknowledge that, and each one, of course, does turn on its facts. But the reason why I say this does assist me is that it comes back to those points that I made at the outset, that it quite clearly establishes, as did Hammersmith, the priority of the social care regime, as you were, over the housing regime. But
that's when, sorry to interrupt, but that's when the both regimes, as it were, are available. If Section 20 isn't engaged in the first place because he doesn't require accommodation, then the point goes nowhere.
Well, it goes somewhere in this sense. The curious outcome of our case, the judge is correct, is that DF was homeless in January and therefore would have been eligible for assistance from housing, as in due course that was provided. What's very odd about that is that if at the same time, at the same date, the judge has found that she didn't require accommodation for the purposes of Section 20. So in other words, by not giving effect to the fact that she was homeless, or reading that across into requires accommodation, it's given rise to a duty under the Housing Act, not a duty under the social services legislation. And that's precisely what Southwark said shouldn't happen. But effectively, housing owes her a duty.
I'm not sure that's an answer to my point, is it? It's assuming what you have to prove that she requires. If she requires accommodation, then Southwark, the ratio of Southwark bites, and clearly the duty under Section 20 takes precedence. If the duty under section 20 doesn't bite in the first place, no question of priority between the two regimes arises.
Well-
Am I misunderstanding?
No, well, no, let me try to explain it again. Perhaps I haven't been clear the first time, I apologise. It's that what Southwark and Hammersmith are authority for is that when a child who is 16 or 17 who is homeless requires accommodation, I appreciate that, come back to that point, but a homeless 16 or 17-year-old should be provided with accommodation and support under the social services legislation. Consequence of the judge's findings, you have a homeless 16 or 17-year-old, in the sense that she's homeless under section 175, but the duty then lies with the housing authority and not with the social care
Well, why is that odd?
It's odd because the whole purpose of the two regimes are that they're to operate hand in hand with
Well,
priority.
that's a point your submissions you haven't got to yet. It's not clear they do operate hand in hand in the sense in which you mean.
Well, my lord, I say they have to, because otherwise you have a child like DF who effectively is falling outside of the social care. I can't put it in any different or better way.
No, I
than
sort
that.
of see it, but I'm just not sure that it works. But I'm testing whether it
Yes,
works. is a
I
fair
see
way.
that. I suppose one has to look at it backwards. It's the consequences of it that are problematic. And the consequences are that as of the 2nd of January, she was owed a duty by the Housing Authority if she didn't require accommodation. And that consequence, we say, doesn't sit with Southwark, where the whole purpose of the way in which the homelessness legislation and the Children Act are meant to work together is that a child who needs housing or requires accommodation, that is provided by social care and not by housing, for obvious reasons, because of the monopoly of other rights that come with the Children Act don't come under the housing legislation. And that's the proposition.
Thank you.
Simply that. It's that the consequence of the judge is if you don't read them as sitting side by side, you will have children like DF. I appreciate it's not necessarily common occurrences, but these facts will arise where children who's living with their parents don't succeed to a tenancy upon a parent's death or a parent removing themselves from the premises. In those circumstances, she's not captured by the social care regime, and that's what we say is inconsistent with Southwark. They've got to fit together. If they don't fit together, she effectively falls through the cracks. Now, maybe there are other bits of section 20 that she also has to hit, but in terms of requiring accommodation, we say that suffices.
Yeah.
Well, that's the way that the judge dealt with this issue. That's paragraphs.
Sorry, can I?
Yes, of course. So sorry.
So sorry. Can I just go back to Southwark? Going back to, just going back as far as section, paragraph 28.
Yes.
So that's the start of the list taken from Croydon and applied
Yes, indeed.
to this case. So the standard things is the child in need, and then the right local authority area, and then the part that we've already looked at, does he appear to the local authority to require accommodation? Then we have the comment about sofa surfing. Then we go on 5, 6, 7, 8, 9. But then at just above 29, it follows therefore that every item in the list has been assessed in the favour that the duty has arisen, that the authority were not entitled to sidestep that duty. So my reading of Southwark always has been is you work out if there is a duty, which again back to require accommodation, and if there's a duty, then you can't sidestep it. I think.
Yes.
Are you saying that as soon as there's been homelessness established, that's the duty, end of?
No. As soon as there's homelessness, you require accommodation. everything else also falls to be assessed because, of course, you still have to be a child in the area.
Again, as I said at the beginning,
Yes.
you're going back every time to what require accommodation.
Yes.
purposes.
Yes, no, I accept. I hope I've been slightly.
Unless you get there, Southwark doesn't make any difference. I mean, it's what we know. If the duty arises, they can't sidestep it. Your case is the duty arose because the young person required accommodation.
So sorry.
Glad it's not me.
Everyone always thinks I'm glad it's not me.
Exactly.
Right. Right. So sorry. I've probably forgotten what the question was, let alone the answer.
I don't think the answer had been given yet, so you've definitely not missed that part of it. The question, as I understand it, was that I'm still back to whether or not requires accommodation has been established. And yes, I'm trying very hard not to shrink from that. I accept that is right. I'm only saying that if you're homeless, you require accommodation. That's the point. We say all the other factors were there, but that's the one that was in dispute effectively.
Yeah.
So that's why
I'm just picking up my Lord the Vice President's point that I'm not sure how Southwark particularly helps us because I don't think it's ever been suggested by the local authority that if the duty arose that they could pass it on to the housing association. The housing authority, what they were saying is the duty never arose. And for me, for my part so far, that ties in and feels to dovetail with Southwark.
Yes, the additional ingredient, the only additional ingredient I say that Southwark gives me is that priority point, and that the consequence then, the judges aren't.
That's the same as the sidestep, isn't it?
Yeah, the priority point doesn't help you. It's the consequences point. You're saying that the mood music of Southwark is that a child should always, a child who is homeless should always get care under the Section 20 and post reaching 18 regime. And I can see how you put it that way, but it is only mood music. That's not actually the issue which arose there.
Well, I'm not sure I would accept that it's just mood music. When you look, one has to look backwards, and that's what the oddity is of this is that you effectively, by not reading homelessness with requires accommodation, she's falling out effectively of requires accommodation. So a duty arises immediately with respect to the local housing authority, not in relation to social care. I can't put it any higher than that, and I say that
It all
is
ties in with your proposition, which you haven't yet come to develop, and maybe there isn't much apart from G which you can base it on, but that the two regimes must interlock. There must be no gap between them.
Indeed.
And you make that point cogently in your Seller's argument. I think that a general proposition to that effect you can't get out of Southwark.
Well,
It explains the relationship between the two regimes in a case where both are engaged.
Yes.
That's all you get.
well, I've made the submissions that I've made.
Yes. No. We're
Accept that, my lord, but that certainly is the argument that I've put. As you said, we do say in our skeleton argument that you do have to read them side by side because
now I see you say that, and are you going to develop that?
I was really going to rely on what we said in our skeleton argument.
Yes. Well, that's fine. I've understood it and been
Yes.
thinking about
I
it a
mean,
lot.
it's more just from a policy perspective, of course, 16 to 17-year-olds being a vulnerable cohort. Parliament having decided effectively that, as I'm developing the submission, I'm really marching straight back into precedence again. I don't want to repeat myself, but it really is, I think, perhaps two sides of the same coin, that one has to read them side by side so that no one falls out, B, no one falls into housing in circumstances where they're a child in need and haven't given consent effectively for doing that. And I was going to take you to the way the judge had put it, but I'm slightly conscious of time, and I'm
Why are you conscious of the time?
trying to march on a little bit.
I see. No, this is all good stuff. You should certainly take us to have.
Let's let the judge
put
has
it.
it, and then I'll deal
No,
with the
we'll
points
only
that
we you're not wasting our time so far, and we will tell you delicately if we think you are. You are. So don't worry.
That's reassuring, if I may say so. The judgment starts at page 104 of the core bundle. The judge starts this issue at paragraph 71, then we'll deal with it through to paragraph 74. The crux of the analysis really is at 73 to 74, so it was really setting up the respective submissions. And you can see paragraph 73 says that the focus of section 175 is on whether a person has accommodation available for occupation. And by contrast, section 20 sets out the duty of the local authority to provide accommodation to children in its area. It says it's thus entirely conceivable that the child may satisfy the section 175 test, but not require accommodation under section 20. Because the child is in accommodation, will remain in accommodation for the immediate or indefinite future, reasonable for the child to continue to occupy it. And then he concludes that off in paragraph 74. It says the first consequence of satisfying 175 doesn't mandate section 20. And that just drives me straight back into the points that I've just been making, that in my submission that doesn't really grapple with the problem that in a case like this, you may be homeless, therefore duties arise in respect to the housing authority, but not under the social services regime. As I've already indicated, that doesn't, in my view, satisfactorily or sufficiently grapple with the priority that needs to be given to social services accommodation. There are a number of points that flow from that, which are picked up in my learned friend's skeleton, which perhaps I just deal with in turn, which build on the judge's reasoning and perhaps pick up some of the points that are made. The first is the point that section 175 is concerned with the person's legal rights, whereas section 20 is concerned with factual circumstances. You see that's not right. That the conditions of actual factual availability and legal rights in section 175 are alternatives. And of course, section 175 may well require an assessment of the legal status of the accommodation that a person is occupying, but of course it would also be apt to cover a person who has no accommodation whatsoever, to accommodate a person who is street homeless, for example. Further, 175.1 is only part of the definition. 175.2 covers a person who has accommodation that's factually available and legally able to occupy, but that for some reason it is not reasonable for him to continue to occupy it. So there are other ways in which you might have accommodation under 175, which is not reasonable for you to continue to occupy. The respondent also refers to the fact that section 20 doesn't explicitly cross-refer back to 175 or use similar language, the ways that it uses the language of requires accommodation as opposed to the language of 175. And we see that's not really surprising, given that children can't hold legal estates in land. I think it's already alluded to that. We've given you the relevant provision in the supplementary authorities bundle. It's
Oh yes, can you just
section
show us that?
Yes, section 1.6.
Oh.
The Law of Property Act. Sorry, just the bundle that's handed up this morning, and it's just page 2 of that bundle.
Yeah.
Section 1, Law of Property Act 1925. Section 1, Legal Estates and Equitable Interests.
Yeah.
And you can see subsection 6 makes that point.
Can a child have a contractual license? Can't see why not.
Malena Junior, who knows rather more about these matters than I do, assures me that the answer to that question is yes, if they had capacity in the way that one would
Yes, so that's what I would have
assess a
thought.
child's ability to enter into a contract. Paragraph 40 of Murder Friend Skeleton, it suggests that the word appears in section 20 is inapt to capture or analyse the legal status of a child's occupation. We don't accept that. So, but of course, assessing whether or not a child appears to require accommodation would require an assessment to be carried out. There's no reason why the social worker in the course of that assessment can't ascertain the status by which the child is occupying whatever accommodation they are.
Can you speak up a little?
Second, shall I repeat that? I was saying that
Yes, please.
the local authority will be required to conduct an assessment in order to see whether Section 20 duties are arisen, as they did here. And there's no reason why in the course of that assessment the social workers couldn't establish the legal status of whatever property it is that the child is occupying. And indeed in this case, social services were told by housing authority that DF was not entitled to occupy it, and that a notice to quit was being served, and so on and so forth. Paragraph 41 said, this is the respondent skeleton argument, said that the difference between section 20 and section 175 is that they're addressed at different decision makers. Well, there's no disagreement about that, it's about the read across between the two. They also say at paragraph 43 that as a matter of common sense and logic, a person may well have proper accommodation, not require accommodation for the purposes of section 20, even though he lacks the particular legal rights specified by 175. And they give a couple of examples of that. The first is where the landlord says in terms that a person can remain on, they won't enforce their legal rights against the individual. We say that's not, of course, what actually happened here, because, of course, Colchester did seek to enforce their legal rights against DF.
Well, yes and no. They served a notice to quit, but they didn't make any attempt to evict pursuant to it.
No, but they certainly made clear from the outset that they weren't just letting DF, that the tenancy was not, that she couldn't succeed to the tenancy, and that she was occupying it as a trespasser, in effect. That was made abundantly clear from the outset, and they did serve a notice to quit. I'll take you to some of the contemporaneous material in a moment, but certainly the position at the time was that Colchester were telling Social Services Authority that she couldn't remain in the property. So just coming back to the examples that were given, we say that actually, in fact, those if you are in accommodation with a landlord saying that they won't enforce against you, in certain circumstances, of course, that might create a licence. It would depend on the facts, but one would have to look at that to see whether or not that generated legal rights under 175.
Well, in various areas of the law, it's not my particular field either, but I've seen a lot of cases. The concept of a tolerated trespasser, although it has no legal concept, is quite well understood. I'm not sure this is a point in your favour or not, but I would have thought that although I haven't seen it used in this particular context, actually that's what the claimant was from the moment of the expiry of the notice to quit, if not beforehand. Because one oddity is the notice to quit isn't actually directed to her because she has no legal right to be there in the first place. But
yes, well,
but you're prepared to argue the case on the basis that she had some right to be there until the expiry of the notice to quit.
Well, I'm prepared to accept that because
It al- as a-
doesn't ultimately make any mileage to me to argue about the period
Right.
behind this.
Well, just looking at that case, thereafter, this isn't really a point I'm making for anyone's point. Is the concept of a tolerated trespasser useful to cover her status there?
Well, no, because certainly up till even by February, Colchester were saying in early February they were saying that they didn't.
Colchester was saying what?
They were saying that they didn't intend. Sorry, man, I'm just looking for the reference. I'll just pull it up. Colchester was saying. Sorry, make sure I'm provided accurately. Certainly on the 8th of February 2023, it's page 44 of the chronology, that they regarded her as a trespasser.
Yes, well,
Page 44.
exactly. But she's a tolerated trespasser in the sense that they're not going to take any steps to get her out for the foreseeable future. That's what a tolerated trespasser means, as I understand it.
Well, it says in terms of that
Denotes.
email that they intend to apply to the courts for a possession order. So the complication in this case is the Colchester was proceeding on the basis of that they needed to serve a notice to quit. In fact, that wasn't correct. But what that email makes clear is
Was that not correct? I hadn't picked that up.
it's not correct because it didn't in fact require a court order in order to gain possession because she was a trespasser. So they were proceeding under a misunderstanding of the need for.
Yes, I see. Yes, of course. Yes.
But the point being, but by the time the notice to quit expired, and to some extent that's why we've hung our hat on that. Just
Yeah.
you can see certainly by that date, there could have been no doubt on the Social Services Authority, no matter what the confusion was elsewhere.
I thought you always had to be a court order, some shape or form. I mean, could they really have sent round some large, heavy men and dragged her out physically? Surely not. Thought it was a criminal offence.
I think your point is, my lord is, with respect, surely right, that they couldn't evict her without a court order, but they didn't need a notice to quit in order to turn her into a trespasser, because she had no right to be there from the start.
Just may I
Sure.
ask the question of someone who knows a little more than I do? But the judge, in fact, as my Jean reminds me, deals with this at paragraph 66 of the judgment. Certainly the finding of the judge below was.
I see, he does say that. Well, that surprises me, like it surprises my lord. Has he set out? I thought the Protection from Eviction Act affected any occupier.
Well, I haven't looked at this again for the purpose of this hearing, but certainly that was the point that was argued below, that in fact, because the Protection of Eviction Act didn't apply, she was a trespasser throughout.
Well, I dare say she was, but even technically, but even trespassers in the more general sense, say squatters who moved in without any buy or leave, the landlord can't just send in large people to remove them without going to court, can they?
Well, I confess I don't know the answer to that, but I will look over lunchtime. I don't imagine that much turns on
May
it
not
with respect
ultimately
for
matter,
our
no, but I think
purposes.
both my lord and I like just to be
I
reminded
take-
what the
I-
position
I
is.
take the point, and I can see that it's a curiosity, and certainly it was certainly argued below on the basis that a court order wasn't necessary. But given that where we've, as time has marched on and here we are now in this court with a
No,
slightly
okay.
different set of
Well,
arguments, I'm not sure it matters too much.
You and Mr. Auburn between us can no doubt educate us as to what the correct formal position
Educate myself, no doubt, as well.
Yes, the judge obviously looked at it quite carefully.
Yeah.
But the bottom line is that she was throughout a trespasser
Yes.
because she had no right of her own to be there.
Yes. Yes.
And if there was any doubt about that, it was certainly terminated by the notice to quit. But but you were telling us that even that wasn't necessary.
Yes. I think the point is probably at some point earlier than that, Colchester could have obtained possession, but they were certainly.
Sorry, can you speak up a little?
At some point prior to that, Colchester could have obtained possession, but they were labouring under an understanding, it appears, that they needed to
Well,
serve a notice
anyway.
to quit.
The why none of this really matters is that with increasing degrees of certainty, Colchester made it clear they were not imminently going to evict her. And the picture got more clear the longer it went on.
Well, I'm not sure I'd accept that, because in January, certainly, the position from Colchester was that they intended to do that.
Yeah, but it was interest of time scale.
Well, I was going to go to this in due course.
You
but-
go to it later. Yeah, right.
I
You
don't
were
want
going
to-
through the points made by the respondents in response,
Yes, and I think.
and you said that there were
probably
two examples of someone who they put forward.
Yeah.
Two examples of someone who was homeless but didn't require accommodation, and one was where the landlord makes clear that that not going to enforce their legal rights, and that's where all the last 10 minutes have kicked off from. What was the second? Did you want to say anything about the second
The
example?
second is someone who's sofa surfing and has a licence to occupy. And there's a suggestion that that child might require accommodation under Section 20, even though they're not homeless for Section 175 purposes. And we would say that that child is probably also homeless for Section 175 purposes, because they have accommodation that it's not reasonable for them to continue to occupy. So in the examples that are given, we say the homelessness legislation and requires accommodation in Section 20 dovetail.
Yeah, okay.
Well, that was all I was going to say on ground one, unless I can add anything further.
Thank you.
Before turning to grounds 2 to 4, I was just going to deal with the overview points that are set out in my letter friend skeleton,
Yes.
paragraph 47 to 50. As I understand the thrust of those points, it's to the effect that the respondent did not in fact take a decision to refuse to provide Section 20 accommodation, certainly until the provision of accommodation by Colchester. That the decision was effectively incremental and gathering of information, and that the approach that we suggest, that a Section 20 duty crystallised in early January, is not reflective of the way in which social workers make decisions. We say that's wrong, and we say that the Section 20 duty arose on Essex where already indicated by, at the latest, by the 2nd of January 2023, when the notice to quit expired. My lord looks concerned, and
I'm really concerned, so I'm trying to hear you.
I'm so sorry.
I'm
trying
I feel
to-
I'm being
I think it's why my
rude
head
saying all
drops,
the time,
it's-
please speak up. So if I'm frowning, that's
I
why.
understand. So we say that's wrong, and that Section 20 duty arose at the point the notice to quit expired. And we said that that's not compatible with the idea that there is a sort of decision-making that continues all the way through January, is not consistent either with the relevant legal principles, the way the point was put below, or with the facts of the case. So, my lord, just in terms of the legal principles, we say that the Section 20 duty arises when it appears to a local authority that a child in need requires accommodation, for a reason in a Section 21, or where it ought rationally to have appeared to the local authority that the child required accommodation. And we say that there are two authorities that support that proposition. The first is GE Eritrea, which I'll show you, and then I'll just give you the references to paragraphs in the second decision, which is Judgment of My Lady Justice King in B, a child, which we put in the additional authorities. So GE Eritrea, it is at tab 426 of the bundle of authorities, page 422.
Sorry, just looking at section 20 again, but I was just your overview point. Does the duty arise prior to the child consenting to it? Answers on a postcard. You see, it's being said by the authority, and we can see from the really helpful chronology that there was comings and goings. Not surprised me, given that she was 17, she wasn't picking up the phone or returning calls or whatever, and then there was suggestions of this and what about cats, and she wouldn't fancy foster care, and what were they housing authority doing, and all those things that were going on. You say 2nd of January, notice of quit expired,
Yep.
duty arises, but I'm just wondering whether that duty actually does arise prior to when
Yes, I see my lady's
an
point.
absolute, when you don't even know whether she wants it.
I would say it does.
26. So you say it does.
But it
And
may
what, then it's dissipated if she says no, I don't want it.
well, it would be effectively discharged in circumstances where she says she doesn't want it. But that must be
Okay.
that must be right, because otherwise, in emergency situations where the classic example of child presenting, the local authority accepts a duty and says, well, this is how we're going to accommodate you. If at that point the child says no, because of course it's not a coercive duty, then of course the section 20 duty falls away. But the same must be true of the parents, my lady. If the parents don't consent, then it's not that the duty hasn't arisen. The duty has arisen, but the parents haven't consented to it being discharged. And the same analysis in my submission must apply to a 16 and 17-year-old.
So perhaps, maybe private thinking about, although the statute doesn't say so, the necessary way in which it is workable is that it's in a sense a two-stage duty. In a case where it would, where it appears that provided the child consents or the parent consent, they have got to offer it, but they don't. The offer then doesn't have to turn into provision if the offer is refused.
But if that's not right, then you can have exactly what happened.
Well,
in
you're
this
agreeing with
case.
that, are you?
Well, that must be right. The duty crystallises, but it is subject to the consent of either the parent.
It's conditional.
It's conditional. Yes, exactly. Better way of putting it. Thank you.
Sorry, I took you off track. It was just
Because
bothering me when
no,
you were saying it.
I understand. It is conceptually a bit odd, but if that's not right, then what happens? For example, you have a bit like the case that I was going to just give the reference to, Be a Child, where the child was an adopted child accommodated with his she was accommodated with her adoptive father. The relationship with the father broke down, and the father sent the child away to live with a relative, or arranged rather, sent away sounds a bit scripted, arranged for the child to go and reside with a relative. In those circumstances, it was held that a Section 20 duty had arisen because the child had come to the attention of the local authority for that, but there was no discussion of consent or so on with the child as to whether the young person in that case, to whether she consented to a Section 20 duty being imposed. And in a way that it would be very difficult to see, particularly in emergency placements, as to how it could be said that my analysis with respect is not correct.
Right, well, that's, you helpfully addressed my lady's interesting point. But you can come back to taking us to GE Eritrea.
Yes, if I may. I'm so sorry, I've lost. It's tab 26, and it's page 422.
Yep.
It is, I accept, a slightly different point, but it's the case here concerned a unaccompanied asylum seeker who arrived in the UK and claimed to be a child. She was detained by the Home Office, but an injunction obtained which required her release, and her release into NAS accommodation, so housing authority, UKBA accommodation as opposed to local authority accommodation. So she was never, in fact, accommodated by the local authority, but she brought proceedings against the local authority claiming that it owed her duties as a former relevant child. And the case is a little curious because it hadn't, by the time of this hearing, been decided whether she was in fact a child. So it sort of proceeded in what you might think is a slightly odd order, but it went up on the question of principle that if, assuming she was a child, there was a discretion in the local authority to treat her as if she was a former relevant child, notwithstanding the fact that she hadn't been looked after them at any point. So the factual background is a little odd in the way that it came on, but there it is. And the question is asked at page 429. Is the claimant a former relevant child? And the court goes on to say, no, there's nothing in the authorities to support the proposition that if you've never in fact been accommodated by a local authority, you can then fall within the statutory definition of a former relevant child.
Sorry, where are we?
I'm just looking, I'm sort of summarising really at page 429. I'm setting up what comes next, but
Yep, okay.
it's 49, the paragraphs, the authorities are reviewed from paragraph 26 on, and then the decision paragraph about nothing in the authorities to say that you can be a former relevant child without being an eligible child is paragraph 33 on page 432. And then there was a question that arose following a consideration of the decision of the Court of Appeal in D in Southwark, and the analysis of that starts at paragraph 35, as to whether you could be a looked after child, whether the section 20 duty arose only after 24 hours of being accommodated. And you can see that question is posed at, sorry, I just lost the reference, bear with me one moment. Paragraph 38. Where in a decision of the Court of Appeal was concluded that the child becomes looked after only where it appears that the child appears to require accommodation for more than 24 hours. And then the analysis is at section 39 and 40. So in other words, it's when does the section 20 duty arise? Does it only kick in after 24 hours? Or does it kick in at the point that the local authority reaches its determination? That's paragraphs 39 and 40.
So I'm getting a bit lost. What are we getting out of this?
It's really that the section 20 duty arises when it arises at the point that it appears to a local authority that the child requires accommodation. And it's really just coming back to those overview points and saying why we say that's wrong, that there is a sort of hard-edged point at which a duty arises. And that's really the thrust of 39 and 40, and also at 41, letter C. In respect of a child in need who requires accommodation, there's no period when no duty arises.
Yep.
And the same point, I don't think it's necessary to take you to it. The same point really comes out of Be a Child. If I could just give you the paragraph references, which considers the comments of Lord Justice Clark in G. Eritrea and agrees effectively. That's paragraphs 54, 59, 60 and 64.
We got it in the bundle.
Yes, it is.
The new bundle.
It's in the new bundle. So sorry, I should have made that clear.
Judgment of my lady.
Yes, exactly right. It's the back of the new bundle, page 20. I can take the court through it if that would help.
well,
I think it's probably repeat.
Unless my lady thinks it would be helpful for us to, it's right that it simply adopts that analysis. You needn't.
So that's my lady. That's the first point, that it's just inconsistent with the authorities, which I say both on a reading of section 20, but on the authorities themselves. So there is a point where that duty crystallises. It's not second the argument that was pursued below. The pleaded position was that Essex had determined that it did not owe her a duty, owe DF a duty under section 20. I'll just give you the references to the DGs and then to the skeleton. I didn't need to take you to them, but it's detailed grounds, paragraph 1A, 31.
Sorry, I haven't. You're going a bit fast for me. What are you seeking to establish?
Well, no, this is a new point. This wasn't.
Yeah, I
below.
understand, but what are you saying that the respondent's position was below?
That they had in fact taken a decision not to offer section 20 accommodation.
At what date?
That was never made particularly clear, except that. But certainly that there was a decision made, which is inconsistent with the stance that my learned friends are now taking, which is that this was an iterative process that persisted throughout January and February.
Okay, is that inconsistent?
Well,
You can take a decision but keep it under review. I'm not going to offer you anything now, but I might offer you something next week. We'll see how it goes.
one could do that. That's not what they said that they did below.
Well, I mean, we'd better show us exactly what they said. But I mean, well,
Does it matter?
Well, that's my lord.
You're saying that over a critical period, they failed to accept, as you say they should have done, that they owed a section 20 duty.
No, my lord is right in that sense. I'm seeking to answer, by way of these submissions, the point that's taken against us, that there is, for example, said to be an air of unreality about the challenge to the decision making that we have made via grounds 2 to 4. Now, that may or may not be correct, but it's seeking to answer that point by saying that the point taken below was the decision had been taken, not that no decision was taken. Maybe my lord is right, that doesn't much matter. I am simply seeking to answer that.
Well, anyway, you were going to show us where it was said that a decision had been taken.
Yes. That's why I show you the detailed grounds. Core bundle 147. So paragraph 1A, Essex did not owe claimant a duty. Page 161, paragraph 31, end of the first substantive bit of the paragraph, Essex was entitled to determine that the claimant did not appear to require accommodation. Paragraph 39 on page 168, last sentence, refers to its conclusion that the claimant did not require accommodation.
So where was that last reference?
Very tail end of para 39, page 168. And para 41, again, the very last sentence, decision that the claimant did not require accommodation was lawful.
Yeah, okay.
There are similar references in the skeleton, I just
Yeah,
to
okay.
pleading.
Okay. So you say not the position below.
Indeed. And for these reasons, really, we say that both as a matter of law, but as a matter of the approach taken below, that's not an argument that can be sustained. Well, so then I was going to turn on to deal with ground 2, which is the departure from statutory guidance.
Yeah.
I was going to just briefly set out our arguments on as to why statutory guidance was departed from, except there may be some, maybe I can take that fairly quickly.
It's in your skeleton argument, isn't it?
Yes, no, that's right, it is, and it's paragraph 3.13 that we rely on, that I've taken you to this morning. That guidance is statutory, as we've already, as I've shown you in the guidance itself, and we say that the position in respect of that form of guidance is most clearly summarised in TG and Lambeth. I can just show you the paragraphs. It's authority tab 22. Page 351. And this was the guidance that TG and Lambeth, it's a Children Act case again, and the guidance that was concerned in this case is identified in paragraph 11 on page 356. Which is the predecessor guidance to the guidance that we were looking at this morning, which, as you'll see, is identified as being guidance that was issued under section 7. So predecessor guidance, same statutory provision. And Lord Justice Wilson, as he then was, I should say that the relevant departures from the guidance, just for your note, were said to be twofold, and they're summarised in paras 12 and 13 of the authority. And the analysis of the legal status of that guidance, or the manner in which it's forced to be considered by a local authority, is set out in paragraph 17, bottom of page 358. There's an extract from the judgment below, Mr. Justice McComb, who stated that the youth offending team should probably, as a matter of good practice, have referred the claimant here to the team in charge of children's social services. So that was what the guidance required. And then you can see the analysis. Perhaps if I just invite you to read letter B below as to what Justice Wilson said was the status of that guidance.
Yep.
So considered decision that there is good reason to deviate from it. That's what the departure from the guidance required. The judge below dealt with this at para 75 of the judgment. That's core bundle 168. I'm so sorry, 126. And he deals
paragraph 126 or page?
No, I'm so sorry. It's paragraph 75 of the judgment, and it's page 126 of the core bundle.
Sorry. Yep. Okay, I have it.
this is the paragraph where he deals with whether or not the guidance had been complied with. He says defendant's duty to have regard to the statutory guidance. The guidance is not a source of law. And then he says the question becomes whether on specific facts there were good reason to depart from the guidance given the reality on the ground. He goes on to set out a series of factors. Over the page, on page 127, says these factors justified a departure from the statutory guidance. In the end, the overwhelmingly likely outcome is precisely what occurred. The defendant gave clear reasons for departing from the guidance that was not determinative. The difficulty was that the local authority had never, in fact, addressed its mind to the guidance. Or
Why should that make a difference?
Because going back to the decision in TG area.
Yes, but why is what Lord Justice Wilson says there right?
Sorry, can I just understand the question?
Yes, Lord Justice Wilson does appear to say, by reference to a judgment of Mr. Justice Sedley, that not only that it may be unlawful, even if the guidance clearly doesn't apply, if the local authority doesn't turn its mind as to whether it applies or not. That seems to me to be odd and unorthodox.
With respect, that's not what I had understood Justice Wilson to be saying.
Oh,
Because in
right.
that case, the statutory guidance did apply, and the submission was that. Perhaps I took
It
the
would
facts
apply
into
in the circumstances of the particular case.
Yes, but if the statutory guidance, as I read the judgment of Lord Justice Wilson in Lambeth, if the statutory guidance does apply, an authority, local authority in Section 7 cases, may depart from that guidance, but only for where they have given consideration to that and given good reasons for it.
Yes. So I suppose really the point I was making wasn't quite right. You have a prior question whether the guidance properly construed was intended to apply in a particular situation. If it wasn't, then it doesn't matter whether the local authority specifically considered it. But if it unequivocally does apply in a particular situation, but they choose to depart from it, then you say that TG is binding authority, that they have got, as a matter of law, to have considered whether to apply it or whether to depart from it.
Yeah, and given good reason for doing so.
What if we were to consider that they were unquestionably right to depart from it, but we couldn't identify any consideration by them? What relief would we grant?
Well, also, could you just repeat the question just so.
Yeah, you could have a situation, I'm not sure it's this one, but suppose it is, where the guidance clearly says you should do X, but the local authority does Y, and the view of the court is that doing Y was the right thing to do. But the local authority has never actually recognised that it is departing from the guidance, or therefore considered whether it was right to do so. But we think it was right to do so. We wouldn't grant any relief in those circumstances, would
That
we?
might depend. It might depend on the reason why the departure from the guidance, why the court thought there was good reason for departure from the guidance. For example, if the guidance was said to be wrong or something along those lines, and there was no challenge to the guidance
Simply
itself, that might
not despite its apparent meaning. That's why there's a slight overlap between the first, despite its apparent meaning, it didn't actually apply in such a case, or it wasn't reasonable to apply it in the particular case.
In that case, it would be open to you to grant. Of course, in any case, that must be right. I can't.
No, I see.
I can't come back from that principle, of course, because that's the application
But
of
by
section
one
31.
route or another, really the important question is, was the guidance intended to apply in circumstances of the present case?
Yes, that I think must be.
Because if it wasn't, either the problem of departing from it doesn't arise in the first place as you're not departing from it on its construction, or it is a question of departure, but it's a reasonable departure.
I would accept that. I'd have to accept
Okay,
that.
thank you. I'm just thinking out
It
what
does
the correct approach
presuppose.
is.
I mean, this ground presupposes that the guidance supplied and that the local authority departed from it. But that's precisely what the judge found.
Yeah.
And that's not a finding that's been challenged. What the judge finds is that there was a departure from the guidance. Then the judge goes on to identify a series of reasons for that, none of which, save in one respect that I'll show you in just a moment, had been advanced by the local authority. And moreover, a number of them, when you look at those reasons, involve matters that, of hindsight, in other words, looking back to see what in fact happened down the line rather than what was apparent on the ground in January 2023. So just to come back to the point that these were not points taken by the local authority, because of course at all times up to the hearing, the local authority were contending that DF was not homeless and was not a trespasser, so they hadn't applied their minds at all to that possibility. There's a witness statement put in from Katie Leach, for your note, supplementary bundle 27, doesn't make any reference in there to a departure from the guidance. The only point for the court is the respondent's skeleton argument, where there's a point made at paragraph 39. Perhaps I just show that to you. It's core bundle page 213. It's 39B, where the authority makes the point through counsel that it's entitled to depart from the statutory guidance where it has good reason to do so. Sets out a reason by reference to the practical realities on the ground. Of course, that was a reason that wasn't there evidence from the local authority of that, or any contemporaneous evidence of that being considered at the time. And that really is the point, that there was, we say, a departure from paragraph 3.13 of the guidance. That guidance is to be followed unless the circumstances in TG and land apply. And those requirements are not met on the facts of this case. 2 points taken against me on this. The first is that it's not pleaded. It is true that the point came up in a slightly roundabout way, in that our pleading below was that DF was homeless and that as a result she required accommodation. In the reply, I'll just give you the reference, we pointed to the guidance as supporting that proposition. That's footnote 5, supplementary bundle, page 5. And the point of departure from the guidance was raised by the defendant at paragraph 39, the skeleton argument for the first time, and that there was a good reason for that departure. The judge accepted that submission, i.e. that there was good reason to depart, and it's from that finding that we appeal. And we say we're entitled to do that. Not required to accept that without appealing it, even if the point wasn't perhaps put in that way, the way that the case developed. The second point is, said will it make no difference, and this is the respondent's notice. The judge didn't, in paragraph 75 of the judgment, say that having regard to the statutory guidance would make no difference. Simply said there were good reasons for departing from it. The respondents in their respondents' notice point to comments made by the judge. Paragraph 119 of the judgment on page 137. This part of his judgment is where he's considering pulling together the factors. It's issue 6, which starts on page 133, was the defendant's decision reasonable in the circumstances, and he's considering here, having homeless and trespassness, whether or not the defendant ought to have considered those factors, and I'll come to that in ground 3, but the point is that the conclusion at the end of 119, the defendant had considered in section 175 that homelessness and trespass, it would be highlighted the outcome would not have been substantially different, is made in a completely different context. It's not linked to the finding on the statutory guidance. So for those reasons, you don't have any recent decision of the judge about whether or not it would make any difference, and therefore we say that that's not, in this case, you shouldn't accede to that argument. Well, just looking at the time, can I do ground 3? I think I can take it very briefly. Over lunch, because I'm then going into ground 4, which is rationality, where I will want to go back to the chronology a little more, and it may be that the lunch allows me then to insert the references and be a little faster in respect of that. So ground 3, failure. The judge was wrong to find that local authorities failure to consider homelessness trespass is lawful. We deal with this in our skeleton at paras 17 to 19. And we deal with we set out the relevant legal test in paragraph 18. Our skeleton argument, I don't propose to repeat that here. The judge dealt with this in paragraphs, starting from paragraph 76 of the judgment, that's page 127 and on. The analysis starts at paragraph 76. And that conclusion, it reaches his conclusions at 79 to 81. What he appears to decide is that the questions of homelessness and being a trespasser were matters to which the local authority could have regard, but not that they were required to have regard. And our point is merely that a child being both homeless and a trespasser are matters that are required to be taken into account implicitly by the statute or as a matter of rationality, because we say they go directly to the question of the suitability of the accommodation. In other words, directly to the question of whether a child requires accommodation or not. So we say he got that wrong in terms of the law. He then picks that point up again when he gets to his overarching rationality section at issue 6, where he pulls the points together and he considers the homelessness trespass point at paragraph 119, it's the paragraph I've just taken you to on page 137. And in terms of the trespasser point, you can see that he accepts the submission, just about the whole punch on mine, that certainly from expiry, C was at risk of being sued for trespass and exposed to risk of damages. It says that one must inject a sense of reality.
Sorry, where are you reading from?
I'm in paragraph 119, my lord.
Yes,
and
but whereabouts?
It's just above the top bullet, the top whole punch on mine. I'm afraid
I must inject a sense of realism.
that's exactly it, yes, my lord.
Thank you.
The notion like a body like CBH, etc., and then he goes on to note at the end of that section, it's not the end of the section, but just a little further down, that one can test the likelihood of CBH pursuing her in trespass by reflecting what CBH actually did on the 17th of February, exercised its discretion exceptionally in C's favour. So he goes on effectively at the end of that section to say that these are all just matters to be weighed.
Well, the end of which
back.
section? End of
I'm so sorry. I mean, it's a very long paragraph.
I know, but just give us some signposts.
It's a little below. It's right towards.
Well, I've read the whole paragraph. Perhaps why don't we've read the whole paragraph before. We can read it again. What are the points you want to make about it?
These that first of all that the paragraph proceeds on the error of law that these are matters just to be weighed into the balance rather than factors that must be taken into account, because of course Essex did not take into account the fact that the claimant was trespassing, because at all relevant times they didn't accept that she was in fact trespassing, given that the whole argument run below was that she was a contractual licensee and that she had a right to remain. So that's the first point. And we say that these are all really material factors that go to the question of the suitability of the accommodation. If you've got no right to occupy because you're homeless and you're a trespasser by way of living there, those are matters that go to the suitability of the accommodation and require to be assessed when deciding whether you require accommodation for the purpose of Section 20.
When you say suitability, it's really precarity, isn't it?
Yeah, and I'm going to come back to deal with that in ground 4. Exactly.
What suitability got to this? Where does suitability come from? I know it's a concept under the Housing Act, but we're not on the Housing Act points at the moment.
I suppose I'm using it as being interchangeable with precarious.
Well, that's really what I was putting to you. Your point is they should have taken into account that she was a trespasser, because that meant that her accommodation was precarious.
Yes, quite.
If they made a judgment that it wasn't precarious or wasn't sufficiently precarious for her to require accommodation at present, then it really doesn't matter what the basis of their legal analysis of that was, whether it was that she was a trespasser or that she wasn't, whether she was a licensee or that she was a trespasser who the council wasn't going to kick out.
That's right if I'm wrong on trespass and homelessness being mandatory considerations.
Being what?
Mandatory considerations.
Why are they mandatory considerations?
Because we say they're so directly relevant to the
But
question.
they're only relevant to the question of precarity, aren't they? Why are they relevant from any other point of view?
No, I accept that, but they go to the question of required. Sorry, I think perhaps we're at slightly cross purposes. They go directly to the question of whether a child requires accommodation, and that's why they are mandatory considerations.
Yes, but we've got to find out, why do they go to the question of whether she requires accommodation? Answer: they go to the question of whether she requires accommodation because they may mean that her accommodation is precarious.
Yes, yes.
But if on the particular facts of the case they don't mean that her accommodation is precarious, then they cease to be relevant, or their relevance is exhausted.
Subject to rationality, ground 4, yes, I accept that. So subject to rationality, yes, because of course the decision on whether or not the accommodation was precarious or not is of course a judgment that's subject to the usual public law principles.
That really gets us to ground 4, doesn't it? Well, I don't want to push you on to ground 3.
No, I accept that there is a degree of overlap between 2, 3, and 4. Okay. I accept that. I accept they've been phrased as separate grounds, but to some extent they do run into each other. I accept that. I'm very happy to start ground 4 now, but
is that a polite way of saying you're not very happy to start ground 4 because you want to just get your ducks in a row?
I think I would be, just given the court's indication this morning that you would, where references made to the chronology,
yes,
prefer to go back
I'm
to
not
the
saying
source
we
material.
want to be talked through the whole story,
No, I
because
appreciate
it's very
that.
well told by the judge now. But I think at 1 or 2 points, if you are going to, as appears from your skeleton, be making points about this exchange and that exchange, speaking for myself, I don't just want to see the summaries of them in a chronology, I want to see the documents. So if it would help you to have a gap to get your references, I'm sure we're happy to sit.
Because I confess that I looked at the bundle below this morning, but not in sufficient detail to be navigating you around it.
No, well, I'm sure we're prepared to rise early if that'll help you. Let's just think about this afternoon. Ground 4, there's a bit of detail in it, but not a lot. You're not going to be on your feet for... How long do you expect to be on your feet for?
My lord, I would have thought no more than about half an hour.
I'd have thought the same. Mr. Alban, obviously that means you've got less time than, if we're going to finish today, than Ms. Hannett, but it's normal and reasonable that the appellant has to cover a lot of the ground, are you confident you'll be able to finish in time to allow her a reply if necessary, if she's sat down at 2:25? Well, if the worst comes to us, we will go into tomorrow. But
Depends
we
how
do,
many questions we
yes.
ask.
Like, I was thinking precisely that.
but the issues have narrowed, and we are going to encourage you, between you, to finish today.
It depends on what your lordship would like assistance
Well,
on.
of course. All right.
You may
Well,
not require assistance on some
Let's
matters. but
stop talking about it and say that we will sit again at yes, the court clock's never terribly reliable. Let's say 5 to 2, and we will not expect you to take more than half an hour unless we slow you down.
That's very fair, my lord.
Which will be a discipline for us as well.